Hi, joining us this hour, former lieutenant with the New York Police Department, Mike Gould, and in Michigan, trial attorney Jamie White. Good morning to both of you. Jamie White, your overall thoughts on how this case is going for the Commonwealth here. There's a long way to go, but to Mike's point, reasonable doubt seems to be seeping in everywhere.
I agree with Mike, and this has been my position on this case since the case first evolved. And there's other factors as well that, while alcohol is no excuse, it clearly appears that everybody on this night was extremely intoxicated. And being from Michigan, while not far from Boston, these weather conditions can be extremely treacherous. So I just have a very difficult time finding any proof beyond a reasonable doubt that this woman intentionally killed her husband. I would suggest, and I think I said this the last time we talked about this case, and I love my wife, this is hyperbole, but there are better ways to commit intentional homicide than these circumstances, and this just doesn't add up. It's certainly not beyond a reasonable doubt.
Jamie, the defense has this theory. They've pushed it since the opening, and they've been able to put the Commonwealth on defense for most of this trial. All of their witnesses are evaluating, are they in on it? Are they in it? Is there a problem, though, or a risk at the end of the day if jurors think, no, I don't believe the defense theory that he went in the house and was beaten up, so therefore she did it? If the defense doesn't prove beyond a reasonable doubt that that their theory is right, is that a risk that they're taking? Because right now they're clearly winning. Everyone's consumed with these others and not the defendant. But at the end of the day, if I don't think I believe the defense, do I then automatically believe the Commonwealth?
I think it was a cosmic mistake to implicate the police officers that were associated with the victim in this case. Because for one, it's not the burden, as we all know, of the defendant to prove anything. And to kind of put, as you've just elaborated, to put a scale in front of the jury, like, was this a conspiracy or was this a murder, is an inappropriate approach to a defense. This could have easily, as Mike said and as we've talked about, been an accident. And again, anybody that's lived in this part of the country, you hit things. The snowplows are building 6-foot banks, and it's a different kind of environment. And then when you throw in the alcohol, it creates a complete cloud over any anticipation that she intentionally knew what she did and let him die.
Yeah. Well, again, if you're wondering where is that fan, I want to watch the Karen Read trial. Well, it's dark all the rest of this week. So testimony yesterday, the rest of the week they're dark. They'll be back at it Monday morning, and we'll be back in that courtroom starting Monday for more live testimony. Still with us, former lieutenant with the NYPD, Mike Gould, and Jamie White is with us as well. He is a trial attorney in the state of Michigan. Jamie, but on the other hand, if there's no direct evidence, if you don't have the murder weapon, how exactly did he do it? Where was it done? And you have a guy that's going through a divorce who's bagging his missing wife to friends. That if you're defending him, how do you approach that? Because it does. To the prosecutor's point, you would expect someone to be really concerned about her. If you loved her so much, you'd be concerned about her whereabouts, and he apparently was the opposite with friends and family during that critical period of time. How do you combat that if you're the defense?
So I appreciate that question, because I want to play the devil's advocate here and just take that position of the defense. And that is that, Ted, show me a divorce with 4 kids in 20 years that doesn't end messy with one or the two parties not wanting the other one to leave and crying and complaining to family and friends, and I'll sell you some lake property in Iraq. This is not. And this is just not unusual, right? I mean, I understand. I joke with my wife all the time. Please don't disappear on me, because you're going to go. You're going to find the 5-minute of text arguments you had over the course of a few years, and it's not going to look good. But at the end of the day, there is no physical evidence that this man committed this act. Now, what I will say, what confronts me as unusual is that, at least what's been presented so far, the manner of death. There's no robbery, there's no sexual assault, there's no kidnapping, there's no bondage. It's simply a strike to the head. Now, that may or may not be the case ultimately once the battle of the experts kick in, but that does suggest to me that this was a personal attack upon her. So I think the prosecutors have a lot of work to do on this case. I'm not saying the guy's innocent, but I think if we're going to live by the reasonable doubt standard, they have a lot of work to do.
Yeah, the injury that seems to be it's going to be a big part of the defense is that this guy's basically a one-legged crutch man because of his knee surgery. The state, right away in the openings, brings that out and says, yes, you're going to hear about the knee. You're going to hear about that he was, and yes, he had surgery, but he could move those hay bales.